Welcome to another Pearl Lemon Legal video. Today we're going to talk about how to win in court without a lawyer. And in fact, whether or not it's even possible. You might be wondering. Some cases seem so complex, there's just no ways. But the reality is, a big reason why Pearl Lemon Legal, the consultancy, even started in the first place was that we were able to win without the use of a lawyer. There are cases where we would still recommend that you go to a professional, a solicitor or a barrister. But here are a few very helpful tips on how you can win your next legal case without involving a costly solicitor or barrister. Here we go. The first step would be to understand how the legal system actually works. And they are separated into different types of courts. So you've got your criminal courts, which are broken up into the magistrates and crown courts. Crown courts are for more serious matters. Then you have your civil courts, which usually start in the county court, but appeals will go to the High Court and then to the Court of Appeal. And there are different divisions of those courts. But as a rule, if it's a criminal case, it's probably going to start in the magistrate's court. And if it's a civil case, it's probably going to start in the county court. Now, there are also tribunals. It has its own structure for dealing with cases and appeals, but decisions go from different chambers of the upper tribunal, and employment appeals tribunal may also go to the Court of Appeal. A very useful tip is something called Court Finder, and we'll even drop a link in the description below. With that link, you can type in your area and find the courts nearest to you. From there, you can then also go on to each court and see which matters they actually deal with. So if there's any uncertainty, you can clear it up before submitting your documents to the wrong court, which can be costly and time consuming. The next thing to consider when you are preparing to go to court is how to research where to find the relevant information. The reality is that a lot of the acts that you would need to be aware of in the UK are freely available online and can be found simply by Googling which act governs the disputes between landlords and tenants, which act governs evictions in Wales. And just on that note, it's good as well to know which jurisdiction you're working with. Is it a contract in England and Wales? Is it a contract in Scotland? These sorts of slight differences can cause you to be in a completely different legal sphere. We once helped someone to evict a tenant, and they'd already started the process and couldn't understand why things weren't working out. The reality was they were living in Wales and weren't using the correct eviction form for where they were. They'd instead used the form applicable to England. And so once we made that correction, things went a lot smoother. So be aware of the jurisdiction you're in. Now, what you might not have that solicitors and barristers would is access to legal databases like Thomson Reuters or LexisNexis. But if your case isn't overly complex, we found that you can get away without using those databases, which are very costly. And a lot of the knowledge and information there is freely available online, just not in as condensed a format. Now, once you've found where to look, you want to know which legislation applies to your case, and you want to understand what your case is actually on. You might feel you've been unfairly or wrongfully dismissed when in fact there's been a breach of contract. You might feel that you would like to evict your tenant under a Section 21 notice when in fact you could evict them under the Section 8 notice for rent arrears. And so it's important to understand the basis of your case. Then you want to organize your documents correctly and properly document the evidence that you have. Unfortunately, too often we do see a lot of very grainy images or videos that don't really substantiate the point that clients are trying to make. The next thing to be aware of is the correct procedure. Now, it's a very broad topic. There are certain principles, which is that you would normally be submitting a form before you're going to a hearing. You would normally receive those forms back prior to finding out when your hearing is actually going to be. But when it comes to things like witness statements, particulars of claim, you may want to address the civil procedure regulations, which are freely available online. There is also quite a bit of guidance on the gov.uk website when wondering how to submit claims, and legal journals and articles from law firms can also be a very helpful resource. It'll just show you or potentially give you an in-depth insight into the procedure that you would have to follow. And the next thing to be aware of is what actually happens in court. How should you appear? How should you speak? First thing to know is that you'll be referred to as a litigant in person if you're representing yourself. You might also be known as an applicant, a respondent, or a dependent, depending on your role in the case. And this will normally be clear from the form that you've either sent in or applied or received rather. You may also be allowed to have someone help you, and that's called a Mackenzie friend. Now, what a Mackenzie friend cannot do is speak on your behalf or get involved in the proceedings. They aren't allowed to sign things on your behalf either. However, they are able to give you advice and guidance, and it is something that a lot of people who might have a bit of legal experience do for others. In fact, it is a service, and sometimes worth considering, just because you are more emotionally involved in a case, having someone that's not attend court with you, or even someone who is a registered Mackenzie friend would be very helpful. The next thing to be aware of is your paperwork and how to compile it. Now, with evidence, you should include witness statements and affidavits, and in those two documents, you should only address evidence. You shouldn't be stating what the law's effect is unless you've been told otherwise. You're basically just stating fact. Now, the next thing would be your skeleton argument, which sets out a summary of what you intend to say to the court. It doesn't include every last detail, but it's broad strokes. This is your case. This is more or less what you believe should occur and what you will be saying. Now, unless the judge has already stated that they have read through your skeleton statement and agree with it, you will need to repeat it in court. You also want to avoid overly long-winded skeleton arguments, just because even though judges do read quickly, making their job more difficult is not going to make your life any easier. The next thing to address is arriving in court. Now, this might seem like common sense, but it's something that a lot of people do get wrong. If you can't be on time, be early. Find the court usher, let them know you're there, and identify yourself. They will inform the judge that you've arrived. Courts will wait a short period of time if the other party has not arrived, and wait outside the courtroom until your case is called. Now, how you address people is also important. There is a need to be polite, to express yourself in a manner that's not offensive or overly emotional, and failing to do that can actually harm your case. Sucking up to the judge does not help either. Raising your voice is a big no-no, despite what TV and American law shows might suggest. It's also not necessary to be overly friendly. Don't get too close to the other party, and remain a professional, business-like demeanor. That, as a rule, would probably be the simplest way to go about how you behave in court. You might also be wondering what actually to call the judge. Well, in different courts, they may be called sir or madam, but by their traditional titles, high court judges, including the intellectual property court, would be called my lord or my lady. You may pronounce these as my lord or my lady. High court masters would be master, and that's gender non-specific. County court judges would be your honor, and magistrate court judges would be your worship. Now, getting that wrong is not the end of the world, but it certainly does cause you to be seen in a better light when you get that right. Then, it might be that you don't need to go to court. And this is something that we help with quite a lot. There are certain things you can do to avoid a costly, lengthy, drawn-out process, and what is actually quite stressful. So a lot of what we recommend is properly following pre-legal action. If you're making a money claim, write a letter. properly refer to legislation and the next legal recourse that would be available to you. Make a compelling argument. If the points that you're raising are contestable, collect evidence to be sent with a letter to say, well, this is what we would be presenting in court, just to make you aware. That sort of thing, in our experience, has actually led to a lot of speedier resolutions and more affordable resolutions for our clients, and in many cases the other party as well. So we would suggest always considering negotiation and settlement as well. It may even be that you've been asked to appear in court, and what would be in your best interest is to agree to, if it's a big debt, a payment plan, or if you've wronged someone, some sort of way to resolve the matter that doesn't cost you their legal fees as well. So I hope you enjoyed the video. That is all for today. Please do like and subscribe to the channel, and stay tuned because we will have more coming tomorrow.